If you hold a green card, a lawful permanent resident card, stop whatever you are doing right now and watch this video until the very end. Because right now, in 2026, the rules have changed, and if you do not know about these changes, you could lose your green card, get denied at the border, or face deportation, even if you have done nothing wrong. I'm going to walk you through every major immigration change that affects green card holders today, what changed, why it changed, and exactly what you need to do to protect yourself and your family. This is not fear-mongering. This is information that immigration attorneys are telling their clients right now. Let's get into it. The United States immigration system in 2026 looks very different from just a few years ago. Under the current administration, immigration enforcement has been ramped up dramatically. But here is what most people misunderstand. A lot of these are not entirely brand new laws. Many of them are existing laws that are now being enforced far more aggressively, with stricter standards, deeper background checks, and less tolerance for errors or inconsistencies. What that means for you as a green card holder is this. Things that used to be minor issues, a small inconsistency in your paperwork, a social media post, an extended trip abroad, can now be serious problems that put your status at risk. And the changes are happening fast. There have been new executive orders, new USCIS policy memos, new rules from the Department of Homeland Security, and new federal court decisions, sometimes all in the same week. So let's break it down into the 4 biggest areas that affect you right now. This is the one that has shocked the most people. If you are a green card holder who comes from one of the countries listed under the expanded travel ban, and this list now covers over 40 countries, your immigration status may now be reviewed or even paused, no matter how long you have lived in the United States. Here is what is happening. US Citizenship and Immigration Services, known as USCIS, has frozen the processing of pending immigration applications, including green card applications and naturalization applications for people from these high-risk countries. And it gets deeper than that. Even if your green card was already approved and you have been living here for years, your status may be re-examined if you arrived in the United States after January 20th, 2021. USCIS is now treating any security concern, including problems verifying your identity documents, as a negative factor in immigration decisions. That means if there is any question mark about your background, your case could be flagged, delayed, or denied. If you are from a travel ban country, you need to speak with an immigration attorney as soon as possible. Do not wait until you have a problem. Act now. This is the change that is catching the most green card holders off guard. Traveling outside the United States has always come with some rules for permanent residents, but in 2026, those rules have become much stricter, and the consequences of getting them wrong are more serious. Here is what you need to know. First, if you are traveling to a country that is on the expanded travel ban list, you may face serious scrutiny when you try to re-enter the United States. Customs and Border Protection officers now have broader authority to review your case at the port of entry. Second, CBP officers are increasingly reviewing travelers' social media accounts during re-entry inspections. That is right. When you come back from a trip abroad, an officer may pull up your Instagram, your Facebook, your TikTok, and go through it. If anything in your posts could be misinterpreted, or if anything contradicts information in your immigration file, it could create a major problem. Third, extended travel abroad can put your green card at risk. Lawful permanent residents are required to maintain their primary residence in the United States. If you spend too much time outside the country, generally more than 6 months at a time, you could be considered to have abandoned your residency. Longer trips require a re-entry permit, which you must apply for before you leave. And here is the part that will affect your future. Travel complications can directly hurt your chances of applying for US citizenship. Naturalization requires continuous residence and physical presence in the United States. Any issues at the border or with travel history will be reviewed during your naturalization application. Bottom line, before you take any international trip, talk to an immigration attorney. Do not assume that because you have done it before without a problem, it will be fine this time. This one came as a shock to many permanent residents who own small businesses. Starting March 1, 2026, green card holders are no longer eligible for SBA-backed small business loans. Under new guidance from the U.S. Small Business Administration, 100% of all direct and indirect business owners must now be U.S. citizens or U.S. nationals with a principal residence in the United States. Lawful permanent residents, green card holders, no longer qualify. This eliminates access to some of the most important federal lending programs in the country, programs that small business owners have relied on for startup capital, expansion funding, and operational support during hard times. If you are a green card holder who currently has SBA loans, or if you are planning to apply, you need to consult with both a business attorney and an immigration attorney to understand your options going forward. This is a significant change that came with very little public notice, and many green card holders are only finding out about it now. The public charge rule is not new. It has been part of U.S. immigration law for a long time. The purpose of it is to ensure that immigrants who come to the United States will not become primarily dependent on government assistance. But in 2026, this rule is being enforced far more aggressively than in previous years. And it is affecting not just new applicants, but also green card holders who are applying for immigration benefits, renewing their status, or petitioning for family members. Here is what that looks like in practice. If you are applying for adjustment of status, which is the process of getting your green card, immigration officers are now conducting deeper financial background checks on you and on your financial sponsor. They will verify income statements. They will compare tax records. They will use integrated government databases to cross-check all reported information. And if they find that a sponsor's income is too low, or that there is any reason to believe that an immigrant might become dependent on government aid, the application can face delays or even denial. There is also a proposed rule under consideration that could make it harder to get a green card if you have received certain public benefits in the past. This rule has not yet taken full effect, but the government has already paused immigrant visa processing for 75 countries while officials apply stricter public charge evaluations. Many lawful immigrants, including refugees, people with temporary protected status, and others, are also facing potential restrictions on accessing programs like Medicaid, Medicare, SNAP, and health insurance through the Affordable Care Act. These policies are rolling out on different timelines, and you need to stay informed. Even if none of the previous changes directly apply to you, this one likely does. Across the board, green card applications in 2026 require more documentation, more evidence, and are subject to more thorough review than ever before. USCIS officers are conducting more in-depth interviews. They are cross-checking information from your current filing against older visa applications going back years. If there is any inconsistency, even a minor one, it can raise serious questions about fraud or misrepresentation. For marriage-based green card applications in particular, the scrutiny has become intense. Officers are reviewing social media profiles, photos, and online activity to confirm that a relationship is genuine. They are checking for inconsistencies between what couples report and what can be verified digitally. The standard of evidence required to prove a real marriage has gone up significantly. For naturalization applicants, people applying to become U.S. citizens, the civics test now includes more detailed questions about U.S. history and government, and higher English proficiency is expected. Processing delays are common, and any prior issues in your immigration history will be carefully reviewed. Employment-based green card applicants are also facing intensive background checks, not just on the employee, but on the employer as well. USCIS and the Department of State can go back through older visa applications and cross-check prior employment history. Any inconsistency can create a problem. The message is clear. If you are filing any immigration application in 2026 for a green card, a renewal, a family petition, or citizenship, You need to make sure every single piece of information is accurate, consistent, and thoroughly documented. One mistake can have life-changing consequences. Okay, so we have covered a lot. Let me bring it all together and tell you exactly what steps you should take right now to protect yourself. Step 1. Review your travel history. If you have spent significant time outside the United States in recent years, or if you are planning international travel, talk to an immigration attorney before you go anywhere. Understand your re-entry permit requirements and know which countries are currently on the expanded travel ban list. Step 2. Review your social media. Go through your public profiles, Instagram, Facebook, TikTok, Twitter, YouTube, and think about how your posts could be perceived by an immigration officer. If something could be misinterpreted or contradict your immigration filings, consider removing it. Step 3. Check your immigration records for consistency. Think about every visa application, every immigration form, every employer you have listed. Make sure the information in your current life matches what is in your immigration history. If there are any inconsistencies, an attorney needs to know about them before you file anything. Step 4. If you are a small business owner, get legal advice immediately. The SBA loan restriction is already in effect. You need to understand how this impacts your business and what alternatives are available to you. Step 5. Seriously consider applying for US citizenship. If you are eligible to naturalize, if you have had your green card for at least 3 or 5 years and meet the residence requirements, now is the time to strongly consider applying. Naturalization provides protections that green card holders simply do not have. It eliminates the risk of losing your status due to travel, criminal history, or policy changes. Step 6. Do not file anything on your own. I know that sounds like something only an immigration attorney would say, but in 2026, this is genuinely important advice. Processing times are long, scrutiny is high, and a mistake on a form can lead to denial or even removal proceedings. These are legal documents with life-changing consequences. Get professional help. Immigration law in the United States is changing faster right now than at almost any point in recent history. The rules that applied last year may not apply today, and the rules today may change again next month. As a green card holder, you have worked hard to build your life in the United States. Do not let a missed deadline, an outdated rule, or an inconsistency in your paperwork put everything at risk. Stay informed, take action, and if you have any doubt about your status or your next immigration step, talk to a qualified immigration attorney. If this video helped you, please share it with someone who needs to hear it. And if you have questions, drop them in the comments below. This script is for informational and educational purposes only and does not constitute legal advice. Immigration laws vary by individual circumstances. Please consult a qualified immigration attorney for advice specific to your situation.